The Supreme Court, in a decision by one vote, has now made Canada the safest place in the world to be a child predator. In a groundbreaking 5-4 decision, the court has now ruled that Canada's police forces require judicial authorization to get an IP address, a warrant to get an IP address. What this has done is essentially halted all investigations into online child exploitation.
We're seeing an immediate impact already where telecoms providers have already denied us information about the IP address.
According to my sources, nearly every child predator case in this country that involves IP addresses has been shut down in the wake of this decision. It's unacceptable. Let's take a step back. Why did the Supreme Court make this decision? It's all about privacy, Section 8 of the Charter of Rights and Freedoms, and a principle called the reasonable expectation of privacy. Now, prior to this decision, it was the rule of the land that you did not have a reasonable expectation of privacy in relation to your IP address. Imagine for a second that there's a hit and run, and the police have access to the license plate. The Supreme Court of Canada is essentially saying, in relation to IP addresses, that they're not allowed to look up that license plate and get the name of the person who potentially did the hit and run. It's ridiculous. You do not have the right to privacy on the internet when you're committing crimes against children. This isn't some hypothetical legal ruling that just happened. This is having real-world consequences today. We have RCMP members who are publicly speaking out, talking about how the judiciary and the telecommunications companies and the ISP providers are already denying them the critical information that they need to crack down on these child predators. This Liberal government is totally asleep at the switch. I even went and asked the Minister of Public Safety at committee if he was tracking this issue. He's not even aware that this is happening. Minister, there was a pretty groundbreaking decision earlier this month of the Supreme Court, the Bayevitz decision. I wonder if you can tell us about what the impact of that decision has been in the last month.
So again, I'm not familiar with the precise details of the decision. Happy to answer Mr. Lloyd's question, but the Associate Deputy Minister would be the best one to give you the precise answer to your question.
This decision has had an immediate effect on basically freezing and, in the words of some RCMP officers, terminating child predator investigations in Canada. And some believe that Canada has now become the safest place in the world to be a child predator. I wonder if you can give your comments on that, Minister.
Well, that obviously would not be a circumstance that's at all acceptable.
This decision came out earlier this month, around the same time that they launched their so-called online harms bill. This online harms bill does nothing to address the fact that child predators in this country are now protected from having their IP addresses accessed by police. Now, you might not be a conservative person, but you don't need to take my word for it. The dissenting judges in the Supreme Court, the 4 dissenting judges, even agreed that this will make it more difficult to prosecute cases against children. But in the end, I don't care what the lawyers and the judges are saying about this. What I care about is protecting Canadian children, and parliamentarians have a duty to override this flawed decision so that we can protect children from child predators. And that's why I believe we need to seriously look into invoking the notwithstanding clause so that Parliament can bring forward emergency legislation to override this flawed law and protect Canadian children. It's time to make Canada the least safe place to be a child predator.